Also, case from supplementary list item 5, first appeal filing number 8069 of 2024.
What is it?
Yes, there's 3 interlocutory applications have been filed. The person who launches order is 12 to 25. First is IA number 251.
So by virtue of filing of this interlocutory applications,
Minus.
your defect stands removed.
Minus. Yes.
Up on
State.
State is the party.
State is also one of the parties. Private respondents.
This is for limitation.
Two limitation petition clause IA number 2511 of 25 is for limitation of the main petition. 15 days delay in the main appeal.
Okay.
That is 2511. Then IA number 1336 of 25 is the limitation in the substitution petition. It was defect pointed out, not thereby we are substituting the legal errors.
1336 is limitation petition actually.
Limitation in the substitution.
Limitation for substitution. The 1336 of 25 limitation for substitution. And substitution is
Substitution of the legal heirs of the plaintiffs who were not made party, that was the main defect.
okay.
That was the main defect of defect number 25.
And IA number 211,
That is the substitution petition.
2118. 2118 of 25 and 1336 of 25 are linked. And this is for limitation of
15 days in filing the main appeal.
the present that you have filed now.
Yes.
FA number, FA filing number 8669 of 2024. Counsel for the appellant has submitted that 3 interlocutory applications have been filed. IA number 2551 of 2025 is a petition seeking condonation of delay of 15 days in filing the appeal. And so far as IA number 2118 of 25 is concerned, the same is for substitution. And IA number 1336 of 25 is for condonation of delay in filing the substitution. The learned counsel for the state is present. Who is representing respondent number?
One.
Are you deputy commissioner?
1, 2,
3,
6.
1 to 6, Sabina.
1, 6. Put away.
DPLR Bokaro, what is DPLR? Oh, so 1 to 6 सभी को तो आप represent कर रहे हैं. The learned counsel for the respondent state is present, right? Pose this case on next Tuesday. आप बताइए कोई response file करना आपको?
I'll have to seek instructions.
The counsel for the respondents pray for and is granted time till 11th March to file counter affidavit to the interlocutory applications, if so advised, post on 18th of March. And the appropriate hearing. नहीं 18th 5th March हो गया ना आप तो 5th March को तो हम लोग रखे ही थे इसको. Post on 18th March instead of 5th of March as directed by the order dated 12 to 20.
That was previously what I was there where
तो बोलिएगा डिसमिस नहीं करना. नहीं मान लीजिए कोई छोटा मोटा छूट गया क्या हो, इससे डिसमिस नहीं करना. आइए पेंडिंग.
From supplementary list, this case for hearing item 9, second appeal 382 of 2018.
Will assist your leadership and he is in court number 3 for a matter which is being continuing in litigation.
आपका तो सुन लिए, आप ही को ना बहस करना है, आप आर्ग्यू करिए.
So far, appellant is taking.
So he has concluded his arguments. इनका पूरा arguments recorded है. क्या बोल रहे हैं आप? 6 February को सारा इनका arguments recorded है, recorded and uploaded, है ना? Learned counsel for the private after the aforesaid dictation of the order, learned counsel for the private respondent, Mr. Abhinay Kumar, appears and submits that he has to file wakalatnama on behalf of private respondents, and today he does not have the brief and therefore he is not in a position to assist this court, and he prays for it. सारा arguments recorded है आप 12 तारीख के order.
हाँ 12 तारीख.
अब तो आप
नहीं 6 तारीख.
6 तारीख को.
6.
ठीक है ना काउंसिल? रिस्पॉन्स के लिए आप उनको बुला लेंगे. अभी पूरा सेकंड हाफ चलने वाला है क्या? पूरा ही हाफ?
He asked me to proceed short answer. I will note down the arguments and
हाँ सर.
After a long time, without having the LCR, I had to prepare the case. But I will rely on the lower appellate court judgment.
No, first you revisit the substantial question of law and then
My
you
lord, my lord. Obliged. The very first page of your lordship order dated 6 February records that substantial question of law.
Can you read it once again?
Yes. And paragraph 3. This appeal was admitted for final hearing on 9th of February 2023 on the following substantial questions of law. Whether the learned first appellate court has committed perversity by ignoring the fact that the vendors of the plaintiff having no title, as she has no document except a sada hukumnama, which is not admissible in evidence, the sentence executed by her in favor of the plaintiff could not have conferred any title upon the plaintiff. Number 2, my lord, whether the learned first appellate court committed gross illegality in holding that the plaintiff have proved their right, title, interest and possession over the suit land by ignoring the fact that the Deputy Commissioner Dhanbad in case number 11 of 82 by order dated 31/12/83 has annulled the thoka containing the suit land, and the land has been acquired by the state government and given to the defendant 4 and 5 appellant by case number 11 into bracket 2/83-84, and delivery of possession of the suit land has been given by the government of Bihar to BCCL while exhibit B on 26/11/87. So, in my humble submission, the substantial question number 2, my lord, whether the learned first appellate court committed gross illegality in holding that the plaintiff have proved their right, title, interest and possession over the suit land by ignoring the fact that the Deputy Commissioner Dhanbad in case number 11 of 82 by order dated 31/12/83 has annulled the thoka. Now, my lord, in my humble submission, annulment of thoka must be preceded by notice under section 14H of the BLR Act.
By notice under section?
Notice should be given under section 4H of the Act, my lord. Annulment of thoka. I humbly pray to this honorable court. Annulment of thoka, my lord, is not under 4H. That is done. Thoka is the rent roll. Thoka is rent roll, my lord, if I understand. And rent roll, my lord, in 1973, a new act came, Bihar Tenants Holdings Maintenance of Records Act 1973. Mutation हम ही मंगा लेते हैं. तो मिलो हाँ यही बन लेंगे. दीजिए.
ये कौन सा एग्जिबिट है?
मैडम
कैंसिलेशन वाला जो डॉक्यूमेंट है वो कौन सा एग्जिबिट है? Do you want to say that the annulment was not under 4H?
मैडम
आपने जो 4H of Bihar Land Reforms Act को रेफर किया,
हाँ.
is it relevant? Because you say that the annulment has not been done under.
नहीं उसमें annulment of salaried होता है उसमें. Annulment of salaried में भी notice पहले आएगा why your salary should not be cancelled because it is contrary to the provisions of the Bihar Land Reforms Act.
That's right. एग्जिबिट नंबर बताइए.
एक एक certified copy of the order sheet of mutation case is not exhibit 10. It is in the impute lower up.
मिल गया इसमें ऑर्डर में लिखा.
We had applied in the trial court also, my lord, for certified copy of the exhibit, but it has not been delivered to us in this period. Or if I am permitted to read the appellate court judgment, my lord, I will be able to place the justification which has been relied upon by the lower appellate court. The points for determination has been recorded at page 8 of the lower of the civil appeal number 119 of 2015. I am permitted to read from there. May I read my? Para 10. Peruse the record. On the basis of the above discussed facts and arguments, in this case, there are only 2 points for consideration, in my opinion, to decide this appeal. Point number 1. Have the plaintiff appellant right title interest over the suit land, and on the basis of sale deed executed in their favor by Devrani Devi. Point number 2. Whether the running Jamabandi of plaintiff appellant were cancelled by the concerned authority. ये थोका जो है ना जमाबंदी को ही बोलते हैं. Whether the running Jamabandi of the plaintiff appellant were cancelled by concerned authority according to law, and is BCCL entitled to hold the suit land on the basis of transfer made to them by the state. As both the points for consideration are interlinked, so to avoid the discussions and appreciation of oral and documentary evidence on record, I have taken up both the points for consideration together for determination. Point number 1 and 2. The plaintiff appellant claimed to purchase the suit land from Devrani Devi. Thereafter, their name were mutated as Sarista of the state. They started paying rent in lieu of their possession of the suit land in Jamabandi number 150 and 151. Later on, state government has transferred the suit land along with other land of village Bhim Kanali to BCCL, defendant number 4 and 5. Then the plaintiff have brought the suit. Shiv Kumar Rai, PW7, one of the plaintiff appellant has stated that on 24/11/82 he has purchased the suit land from Devrani Devi through registered sale deed. Then after their name mutated under Jamabandi number 150 and 151, they started paying rent to the state government in lieu of their possession. He has claimed that plaintiff appellant are still paying rent to the state government. Vasdev Pandey, PW10, is formal witness who has proved the rent receipts. Shiv Kumar Rai, PW6, has stated that earlier Devrani Devi was paying rent to the state government in lieu of her possession of the suit land on the basis of Hukumnama executed in her favor of the ex-landlord. Gokul Chandra Pandey, PW8 has proved the rent receipts in Exhibit 5 series of the plaintiff and their vendor. Abhayanand Prasad, PW9, is another formal witness. He has also proved the rent receipts Exhibit 2 series. Prahlad Chandra Pramani, PW7, has proved certified copy of sale deed number 12734 dated 24/11/82, Exhibit 3, through volume number 2, which he brought from registry office to the court of as per order of the court. He has also proved sale deed number 12735 dated 24/11/82. Two sale deeds were executed manually of 1 acre 50 decimal each. Shiv Kumar Rai, PW6, has further stated that Shiv Kumar Rai is one of the plaintiff members, has further stated that he has given the original sale deeds to his learned lawyer which were misplaced. Then he has filed certified copy of the sale deed. He received no notice from CO office regarding cancellation of his Jamabandi. Inderjeet Prasad, DW1, he is for BCCL only. He was the Amin of BCCL. Has deposed before the court on behalf of BCCL, defendant number 4 and 5, and he stated that he was appointed as Amin in the year 1981 in BCCL. The suit land is about 3 acres of land under Khata number 45, plot number 125 of village Bhim Kanali, which was recorded during cadastral survey operation as Gair Abad land. On perusal, this Gair Abad land, my lord, in fact, the original stand of the defendant was that it was a Gair Abad Malik land. Simply saying Gair Abad will be having two faces, either Gair Abad Malik or Gair Abad Am. On perusal of certified copy of the Khewat Exhibit 8 and 9, I find that Khewatdar of Bhim Kanali were Manilal Singh Chaudhary, Khewat 1 by 1, Mahavir Singh Chaudhary, Khewat 2 by 2, under Khewatdar Babu Neelkant Singh Chaudhary of Khata number 1. Khewat number 2 by 3 was under joint Khewatdar Khewat number 2 by 1 and 2 by 2. Khata number 45 of village Bhim Kanali having 3 plots, that is plot number 125, area 3.70 acre. इसी से वो 3 एकड़ हम लोग खरीदे 2.248, that is plot number 248, area 54.04 acre, and were recorded as Jungle Jha, whereas plot number 197 having area 28 decimal was recorded as House and Country Yard. The certified copy of the Khewat is Exhibit 9. Another plot, that is plot number 107, was recorded Bharti, having area 1.43 acres. Obviously, during cadastral survey operation, plot number 125, Khata number 45 of village Bhim Kanali was Jangat Chhari and Gairabad Malik land, which finds support from the deposition of Indrajit Prasad DW1, who has further stated that Bihar government has issued armed istihar on 18/5/83 and invited objections. The certified copy of istihar is Exhibit A on paper. On perusal of same, I find that istihar was also issued for an area of 3.70 acre of plot number 125 of Khata number 145 of Bhim Kanali. Then istihar was issued from Office of CO, Bagmara, and it is written that 58.35 acre of land of village Bhim Kanali are to be transferred to BCC. The land under istihar as per the claim of the CO Bagmara is recorded in the name of Government of Bihar. On perusal of certified copy of order dated 29/1/2009 passed by the then settlement officer Dhanbad Sri B.B. Verma in suit number 5125/05 instituted under section 87 of the CNT Act, Exhibit 11 by A, I find that the learned lower court of Sri B.B. Verma settlement officer Dhanbad has allowed that suit. On perusal of the order dated 29/1/2009 passed by the learned court of settlement officer Dhanbad, I find that Shiv Kumar Roy and others have filed this suit against Bihar government and others under section 87 of the CNT Act for correcting record of rights published during revisional survey operation for Khata number 45, which was recorded in the name of the state of Bihar. After hearing alert, incorrectly it was recorded as Malik, state of Bihar. The settlement officer, after hearing the case under section 87 of the CNT Act for correction of the Khatiyan, found that it was incorrect and it should have been in the name of Shiv Kumar Roy, the plaintiff of the case.
The cancellation order is dated.
Cancellation order of the Jamabandi is Miller.
Is dated.
1 minute. It started from 1983. Case number 11 under bracket 2 of 83, 84. Order dated 10/5/83 to 11/10/83. The running demand of various tenants were cancelled. My lord will find at page 11, running page 26, top 3 lines. I will come on this, my lord, that the revenue authorities, the deputy commissioner and his subordinate officers in the district do not have any right to cancel Jamabandi. It has been now set at rest, my lord, in the case of the state of Jharkhand versus Izhar Hussain. Now, my lord, that has also attained finality after the SLP was dismissed by the Honorable Supreme Court of India. Yeah.
Shiv Kumar Rai, you are representing Shiv Kumar Rai.
Ji. Plaintiff was Shiv Kumar. My lord will kindly allow me to place a judgment of a division bench of this Honorable Court dated 5th November 2020 in LPS 786 of 2018, the state of Jharkhand versus Izhar Hussain. May I place it, ma'am?
नहीं हम एक सेकंड देखेंगे उसको. पहले आप हमको ये बताइए कि ये जमाबंदी किसके नाम से चल रहा है?
जमाबंदी मेरे नाम से थी.
आपके नाम से मतलब?
इस शिव कुमार राय and his brother.
एक सेकंड. शिव कुमार
They were the
Rai
plaintiffs
and his brother.
and his brother. From the
एक सेकंड.
decree and original suit I can place.
Just a moment. And एक सेकंड. You were the plaintiff.
I was the.
कब से चल रही थी?
Well,
कब से चल रही थी? What is the source of your title?
I am a purchaser
Purchaser from?
from Devrani Devi. From Devrani Devi.
Devrani Devi. Right? Sale deed number?
Sale deed number. Just please. Sale deed number, my lord. Sale deed number, my lord. Sale deed number is, my lord, 12734 dated 24/11/82. Exhibit 3.
24/11/82.
82.
Okay, 82.
24/11/82.
Exhibit 3.
Sale deed number 12734.
12734. Okay. Now the point is, Devrani Devi,
Ji.
she is a purchaser or what?
No, in fact, she was wife of the ex-zamindar.
Just a
And
minute.
ex-zamindar had settled her 3 acres of land.
Devrani Devi,
It has come on the record.
wife of, just a moment,
Huh.
ex-zamindar,
Yes.
who settled how much?
3 acres of. She got 3.70 acres
3.70 acres
Minus.
through settlement.
through Sada Hukum.
Sada.
Ji.
When? What is the date?
On 8th of Ashwin, 1353 Bangla Summer.
हाँ,
Yes.
बताइए कौन सा होगा?
Over
Corresponding
19,
relation.
1353 comes to 1943 AD.
1942, 43
43.
AD. Okay. Then she must have come in possession of the property.
Yes, madam. She came in possession, and from 1946 she started paying rent. And when the state of Bihar started,
So when you say that since 1947, 46 or 47,
40,
from 1943 till 47, there is no rent receipt.
मेरे पास नहीं है, उनके पास होगा. She was wife of the zamindar, so there is no question that it was created later on.
No,
It
no.
was a
When you
genuine
are talking
document.
about hukumnama,
Ah,
hukumnama is of no use unless it is coupled with delivery of possession and
Yes.
issuance of rent receipt.
it was delivery of possession was there.
From where do we get this? You say 1943, hukumnama is there.
Madam.
That is the only document which you have exhibited,
Madam,
right?
which the lady had given to us
That's right.
in 1982, madam.
Hukumnama. But no rent receipt as such was produced.
She gave the rent receipts. They are rent receipts 2 series. There are 3 set of rent receipts. The rent receipts 2 series Miller are issued in favor of Devrani Devi.
So you are relying upon 2 series. It is issued by
State of Bihar.
State of Bihar. When? When?
In those days, Miller,
In those days में State of Bihar का तो डेट होगा ना? बताइए. कब देवरानी देवी के नाम पे सबसे पुराना रेंट रिसीट आपने कौन सा प्रोड्यूस किया? Exhibit 2 series, right?
just if I exhibit 2 government rent receipts, exhibit 2 by A to 2 by 2 government rent receipts dated 31/3/83. 31/3/83. Exhibit 1 is carbon copy of advocate's notice under section 80 of the CPC. This was also denied by the defendant, state and BCCL. In fact, BCCL stepped into these shoes, Miller, after it was handed over to them.
आप खाली अपना देवरानी देवी का कहानी सुनाइए,
हाँ।
बीसीसीएल अपना कहानी खुद सुनाइए, ठीक है? आप खाली ये बताइए देवरानी देवी के नाम से ओल्डेस्ट रेंट रिसीट कब का है?
Para
1983 का है।
2 में हम लिखते हैं, हम पढ़ते हैं, shortly stated the plaintiff appellant case as find place in the plain of title suit number 73 of 90 is that the suit land was recorded as Gairabad Malik in the last survey operation under Khata 45, which consists several plots. Devrani Devi, wife of Bhuvaneshwar Singh Chaudhary, took settlement of 3 acres of land out of 3.70 acres under plot number 125, Khata number 45 of village Bhim Kanali, PS Bagmara, district Dhanbad, by Hukumnama Exhibit 7. Hukumnama is Exhibit 7. Dated 8th Ashwin 1353 BS, that is Bangla Samman, granted by the landlord. Devrani Devi was mutated for the settled land under Jamabandi number 79, and she was paying rent to the state after vesting of estate in the state of Bihar.
यही तो बात है, आपको हुक्मनामा मिला देवरानी देवी को,
हाँ।
और सीधा रेंट रिसीट स्टेट का है, जमींदारी रेंट रिसीट कोई है नहीं।
स्टेटमेंट है पर वो है नहीं।
कहाँ है स्टेटमेंट की जमींदार को रेंट दिए?
हाँ लिखती है ना, देवरानी देवी was mutated for the settled land under जमाबंदी नंबर 79।
when
नहीं है तो हम
सर आगे
and she was paying rent to the state after vesting।
ये म्यूटेशन तो स्टेट ही किया होगा ना भाई, जमींदार के यहाँ म्यूटेशन नहीं होता था, जमींदार के यहाँ हुक्मनामा हुआ और रेंट रिसीट इशू हुआ, यही चलता था। जमींदार अपना जमींदारी रिटर्न में जो बोल दिया सो बोल दिया,
अच्छा,
ठीक है।
रिटर्न
म्यूटेशन, अगर म्यूटेशन की जहाँ बात आती है, द रोल ऑफ द स्टेट कम्स इनटू,
यस मैम।
तो जमींदारी रेंट रिसीट तो कहीं है ही नहीं उनके नाम
so
से।
far return is concerned, my lord, subject to correction, I have not come across any zamindari who has submitted his return in the district of Dhanbad।
आपने
There
नहीं
was
देखा होगा, लेकिन हम लोगों ने एग्जिबिट्स में देखा है जमींदारी रिटर्न्स।
धनबाद का
अब धनबाद बोल के तो नहीं बोल सकते हैं, लेकिन वैसे देखा है।
what I am saying, one of my seniors argued in the court also, later on he became judge and Supreme Court judge, a very celebrated person, but that is not the concern। I have also not come across in my last 43 years of practice any such return in the district of Dhanbad। The case is that she was in peaceful possession of the land and she has at least paid rent to the state of Bihar after mutation in Jamabandi number 79। And how the Jamabandi could be cancelled by Deputy Commissioner? The state ought to have filed a suit in view of the several judgments of this honorable court and honorable Patna High Court।
आपके जो डीड है ना एग्जिबिट 3,
जी
आपका डीड है ना,
हाँ,
उसमें भी ओल्डेस्ट रेंट रिसीट इज ऑफ द ईयर 72
हाँ,
और उसके बाद एक है
मेरे पास-
58 का। नहीं, डीड में जो जिक्र है हम उसकी बात कर रहे हैं, जो लिखा हुआ है डीड में उसकी बात कर रहे हैं।
हम तो
जमींदारी
अपने से
रेंट
लिए-
रिसीट अगर नहीं है आपके पास तो हुक्मनामा के बेसिस पे उनका टाइटल एस्टैब्लिश नहीं हो सकता,
Lord,
और अगर उनका टाइटल नहीं है तो आपका टाइटल नहीं है। एकदम सीधा सा सवाल ये।
पोजीशन है,
हाँ, पोजीशन है,
जमाबंदी है,
जमाबंदी आपका था।
है ना? How it could be cancelled
जमाबंदी का कैंसिलेशन और जो भी कुछ है वो छोड़ दीजिए, हम मान लेते हैं आपकी बात की कैंसिल रनिंग जमाबंदी को ऐसे कैंसिल नहीं किया जा सकता। लेट अस assume that to be a correct
तो
proposition.
जमाबंदी will be on the basis of possession। Now one thing more will come which yesterday came to my mind। जमाबंदी हुआ है तो land must be a रैयती land और बारी और घर, और कहते हैं कि मेरा घर बारी है। बारी is not the courtyard where they grow vegetables in the villages।
You went for declaration of your title. What was
Yes.
it? It was declaration of your title
Yes my lord,
on the basis of registered sale deed.
registered sale।
Correct?
हाँ,
Now,
उसमें जो स्टेटमेंट है एटलीस्ट उसको तो देखेंगे ना।
अगर मान लीजिए कि अभी your continuing possession or the possession has been handed over to the applicants.
Right now today I cannot say, but मेरे पास not a chit of lower court record is available। I asked my client, my junior, to ask the client and the client has applied for a certified
आप
copy।
पिछली बार बोले थे ना सर कि
हम
सारा
देखें।
रिकॉर्ड यहाँ पर है।
हम लोग देखें, and from reading that minute, what comes to me, ये लगता है कि वहाँ से नहीं आया होगा, ये हमको लगता है कि वो लोग भेज दिए होंगे थ्रू ईमेल या कुछ भेजे होंगे।
वही आता है। अब तो वो सिस्टम ही खत्म हो गया, ओरिजिनल रिकॉर्ड किसी केस में नहीं आता।
नहीं ठीक है, अच्छी बात है। तो उसका अगर एक कॉपी हमको मिलता ना,
नहीं मिल सकता है सर, ये इसका कॉपी का कॉपी हम नहीं ले सकते।
आप एक चीज सोचिए ना वाला कि मेरा ही कागज है।
ये लीजिए, आप ही का कागज है, आप लीजिए और बहस करिए, उनको दे दीजिए, सारा रिकॉर्ड दे दीजिए।
नहीं ऐसे कैसे
नहीं,
होगा?
आप ले लीजिए, कोई
हम
दिक्कत
पढ़ेंगे उसको समझेंगे तब तो प्लेस करेंगे।
आपको तो हम बोले थे, आप रिकॉर्ड देख लीजिए, पिछली बार भी
हम
आपको
देखें,
बोले थे।
मेरा give me the
देखे हैं तो बता दीजिए।
sheet of paper.
आपसे एक ही सवाल खाली पूछ रहे हैं पूरे रिकॉर्ड में,
Madam,
पूरे यही चीज है और यही उनका आर्गुमेंट ही यही है। उनका आर्गुमेंट पूरा रिकॉर्डेड है पिछले ऑर्डर में। आई एम श्योर यू मस्ट हैव रेड इट।
I've seen.
यू हैव सीन इट। उनका यही आर्गुमेंट है, इसके अलावा कोई आर्गुमेंट नहीं। हुकुमनामा इज नॉट अकम्पनीड बाय एनी जमींदारी रेंट रिसीट एंड देयरफॉर हुकुमनामा, देयरफॉर क्लेमिंग टाइटल ऑन द बेसिस ऑफ हुकुमनामा इज नॉट परमिसिबल। बस इतना बार यही है ना आपका आर्गुमेंट। इतना ही, इतना छोटा सा आर्गुमेंट है, इसके अलावा कुछ नहीं है।
मेरा हम
आप आपको जजमेंट से दिखाइए,
हम
जजमेंट से दिखाइए कि आपका कोई भी रेंट रिसीट है क्या, जमींदारी एक भी रेंट रिसीट है क्या आपके पास?
I will rely on a few judgments, my lord. Let me read the judgment of the appellate court. It has considered those things. उसके बाद तो हम प्लेस करेंगे. I will rely on certain judgments.
You see, creation of जमाबंदी or cancellation of जमाबंदी will not decide the title of a person.
Yes, but
This
it
is
will-
very clear. It will have a bearing on the possession.
Possession and possession of what? It must not be a barren land. It must not be a
इससे
state
कोई
of
मतलब नहीं है
how
barren
the
land है
state
क्या है।
how the state government will realize rent
जब ये
for its own land.
जब ये एक्विजिशन हुआ तो नोटिस हुआ होगा आपको?
नहीं, एक्विजिशन का नंबर दे दे.
अच्छा, एक्वायर नहीं हुआ,
नहीं,
Illegally
एक्विजिशन
घुस
केस
गए।
नंबर दिखा दे और हमको नोटिस हुआ वो एग्जिबिट किए वो दिखा दे. स्टेट गवर्नमेंट हैज नॉट. एक्विजिशन केस लैंड एक्विजिशन केस नंबर सो एंड सो अगर ये दिखा दें तो आई विल अप्लाई फर्दर इन्वेस्टिगेशन. है ही नहीं. Since I had only the trial court and appellate court judgments, I have gone through it.
आप हमको ये बताइए कि इंटरनल पेज 11
मैं
का बॉटम,
running page 26 मैडम.
रनिंग पेज 26 का बॉटम में है।
The state government has given the land to BCCL by case number 11/283-84 order dated 10/5/83
नहीं, उसमें एकदम नीचे आ जाइए लास्ट में, एज पर द फैक्ट्स ऑफ दिस केस, ये एकदम लास्ट लाइन, एज पर द फैक्ट्स ऑफ दिस केस एक्स लैंडलॉर्ड हैव सेटल्ड
the certified copy of the
इंटरनल पेज 7 ऑफ द एपीलेट कोर्ट ऑर्डर,
7.
इंटरनल पेज 11
As per settled principle of law, a long-running Jamabandi cannot be cancelled unless fraud and misrepresentation is established in opening Jamabandi. और
ये
ये
तो
कहाँ
सेटल्ड है, इसमें कोई दिक्कत नहीं है। आप लास्ट लाइन में आइए ना,
the creation
लास्ट लाइन में उसी पेज के लास्ट
हम
में,
इसमें
एज
ये
पर
करें।
द फैक्ट्स, दिस इज
the
एब्सोल्युटली इन
creation
योर
of
फेवर।
Jamabandi gives a valuable right to the reader. For this part of my finding, the reliance may be placed upon the case of Sri Kanak Kumari Devi and others versus State of Jharkhand reported in 2008 volume 2 JSR 572 and also on the case of Dineshwar Prasad versus State of Jharkhand and others reported in 2008 volume 3 JSR 273. Srimati Gulabasi Devi versus State of Bihar reported in 2003 volume 4 JCR 41 Jharkhand. As per the fact of this case, the ex-landlord have settled the suit land in favor of Devrani Devi by Sada Hukumnama Exhibit 7, and thereafter she started paying rent to the ex-landlord.
बस इसका कोई मटेरियल दिखाइए, ये फाइंडिंग है,
हाँ.
इस फाइंडिंग का मटेरियल दिखाइए। any material on record to show to substantiate this finding.
मतलब
Any material, कुछ भी दिखा दो. Any material from the record to substantiate this finding of the learned applicant.
that may be statement.
Sorry,
कि हमें सेटल हुआ और हमने रेंट पे करना शुरू कर दिया
statement.
एक्स लैंडलॉर्ड को.
किसने पेमेंट किया? देवरानी देवी तो आई नहीं. देवरानी देवी तो आई नहीं है ना एविडेंस देने.
नहीं.
शी इज नॉट देयर. आपके सेल डीड में भी कहीं नहीं लिखा है. लेट मी एज्यूम, ठीक है, उसमें भी कुछ भी नहीं लिखा, जबकि उससे भी कुछ नहीं होता है.
When my lord is saying, I will take it as a
नहीं,
authentic
ऐसा
words.
नहीं है. वी आर जस्ट डिस्कसिंग. लेकिन जब कोई चीज का मटेरियल पर होता है तो दे कैन बी ए मिस फ्रॉम माय एंड आल्सो. हो सकता है देखने में गलती हो गया हो, पॉसिबल है ना. लेकिन पूरे रिकॉर्ड में एट द टाइम ऑफ एडमिशन आल्सो, जब सब्सटेंशियल क्वेश्चन अपना फॉर्मुलेट हुआ था, उस समय भी आई थिंक आई हैड ओनली फॉर्मुलेटेड द सब्सटेंशियल क्वेश्चन. उस समय भी वी कुड नॉट फाइंड एनीथिंग. पूरे जजमेंट में तो कहीं नहीं है, पूरे रिकॉर्ड में भी कहीं नहीं है.
But for a moment, for the sake of submission, not admitting, for the sake of submission, let me assume that although she had paid rent, there is no proof of it.
नहीं नहीं, ऐसा एज्यूम नहीं करना. हाउ डू यू से दैट शी हैज पेड रेंट?
Well, in fact, she was for a lady of the house
सो
who were the zamindars. So this may be possible that the rent receipts could not be searched out, could not be given to the purchaser.
शी इज अ लेडी ऑफ द हाउस एंड देयर इज अ हुक्मनामा, तो डिलीवरी का तो कोई सवाल ही नहीं उठता है.
तब तो हमको डिलीवरी मिल गया ना by the हुक्मनामा. And Patna High Court says, my lord, a special bench, because 5 years bench.
उगनी देवी,
My lord,
उगनी देवी,
my lord, Ugni Devi,
पैरा 26
my lord.
पढ़ी. इसी की ही बात बोल रहे हैं आप.
26 is
26 नहीं, याद नहीं.
16. एक ही बात
जजमेंट
दे रहे.
आपके पास है?
हाँ.
लाइए. ये 64 पटना को डिस्टिंग्विश किया है.
जी.
डिस्टिंग्विश का बात नहीं कर रहे हैं.
नहीं, इसमें कोई फाइंडिंग करते हैं. For these reasons, I would hold that the full bench decision in AIR 1964 Patna page 1, on which Mr. Premlal relied, will not apply here. In view of the clear finding of the lower appellate court that the plaintiffs came into actual possession of the lands, continued in possession, and paid rent to the landlord.
यस, यही आपको
तो हम लोग तो दे रहे हैं रेंट.
टू द लैंडलॉर्ड. एक्स लैंडलॉर्ड को पेमेंट ऑफ रेंट चाहिए.
अब तो लैंडलॉर्ड स्टेट ऑफ बिहार उसको दिए, फिर स्टेट ऑफ झारखंड को दिए.
ऐसा नहीं. हुक्मनामा के साथ डिलीवरी ऑफ पोजेशन तभी प्रूफ होगा जब आपके पास रेंट रिसीट है ऑफ द एक्स लैंडलॉर्ड.
नहीं, इसमें भी नहीं था, उगनी देवी में भी नहीं था. Let me read for kind consideration of this honorable court. Finding of lower appellate court that the plaintiff came into actual possession of the lands, continued in possession, and paid rent to the landlord, and obtained rent receipts for the disputed lands. On these findings, their rayati interest was established. The possession of the plaintiff, as found, was for more than 12 years, and hence, even in absence of a finding that the plaintiffs were settled rayat of the village, occupancy rights will accrue to them. Too much importance should not be attached to the somewhat incorrect observations in para 12 of the judgment of the lower appellate court quoted above in view of its dear discussion of oral evidence of possession in para 12 and its finding in favor of the plaintiffs. It has also held disagreeing with the trial court that the rent receipts produced by the plaintiff were in respect of the disputed property. I have already shown that in the plaint, an alternative case of acquisition of royalty interest by virtue of possession and acknowledgement of tenancy by acceptance of rent by landlord was put forward. The unregistered hukumnama, though inadmissible, could be looked into to show the nature and character of possession. Oral evidence of the terms of the lease was not be admissible, but independent of hukumnama, the rent receipts themselves indicate the rate of rent, the area and nature of right of the lessee. Hence, the independent of hukumnama, the terms of the royalty settlement were inferable from other places of evidence, which were rightly relied on by the lower appellate court. Therefore, I say, my lord, that my lord may allow me to read the judgment of the appellate court. There is no error of law that could justify our interference in second. For these reasons, the appeal is dismissed with cost payable to the plaintiff respondents. This is my humble submission also.
So you are relying upon which paragraph of this judgment?
Para 16 and 17.
16 and 17.
Now, from other sources also, my lord will find that the day we have purchased, we applied for mutation and that was allowed. And that they say, the state says, कि वो गलती से allow हो गया. Judgment of this honorable court says कि even if incorrect जमाबंदी has been created, that cannot be cancelled by the revenue authorities. The state will have to go to a civil court for cancellation of jamabandi. So, in my humble submission, the order of the learned deputy commissioner cancelling the jamabandi, taking possession from the plaintiffs was illegal. And taking possession means, my lord, cancelling jamabandi, my lord, shows that we were in possession, therefore we were deprived of the hoka and jamabandi. And then the land was taken possession of and given to BCCL. My lord,
You were evicted from the property.
my lord,
You were evicted.
my friend will say,
It is an admitted case of the plaintiff that possession is with BCCL. They say the state authorities are handed over the possession to BCCL.
Is it their case that by virtue of cancellation of Jamabandi they were dispossessed?
They don't say
No.
so. They say subsequent to cancellation,
The property was handed over.
yes. So, my lord, cancellation of jamabandi, my lord, was illegal. Taking over possession was illegal.
Look, there are two different things. Cancellation of Jamabandi is one step, and taking over possession is another step.
My lord,
Did they take over the possession after cancellation of Jamabandi?
I will have to.
Because the cancellation of Jamabandi order is not reflecting that they will take the possession from you. That order exhibit is not reflecting that they will take the possession from you. It is
Therefore-
only an order of cancellation of Jamabandi.
Then what was mutated? Name of the previous title holder was cancelled and my name was inserted. That is called Dakil Kharij. My name is Dakil, done Dakila, and the name of the previous owner is removed, that is Khari.
That's right. Now there is further finding that after vesting of the estate to state government, she was paying rent to the state. Vesting के बाद पहला rent receipt कौन सा?
वो शायद 1962 का है। जरा सा ये तो LCR। May I pray, my Lord, that if it is kept parted, and I may be
Sir,
given a
बहुत सारा
chance to
cases
obtain a certified copy of
नहीं सर,
the.
आपके पास है, आप देख लीजिए। 2 सीरीज सब फ्लैग ही किया हुआ।
And that is also, my Lord, I will have to rely on certain evidences also, my Lord.
So basically, your case is that the cancellation of Jamabandi was absolutely illegal. Running Jamabandi could not have been cancelled. And the fact that the Jamabandi was running in your name, it itself goes to show that you were in possession of the property.
And it was not a barren land. My statement is that in the plaint, as I have read from this LCR, that we were in possession, we were having house and bari. Few things I remember. So
House and bari was there. And in a place where house and bari is there, then under such circumstances, either they cannot be just, it is not a vacant land that anybody will
जी.
claim possession. तो आपको डिस्पोजेस कब किया? कोई डेट है आपके डिस्पोजेशन का?
then oral evidence शायद देखना पड़ेगा.
कोई डॉक्यूमेंट्री एविडेंस तो नहीं है और ना ही आपका कोई केस है कि आपको डिस्पोजेस किया गया इस पर्टिकुलर, ऐसा कोई केस भी नहीं है आपका।
जिस समय केस फाइल हुआ है, that day I was in possession. Therefore, I have sought permanent injunction.
That's right.
Prayer is
The relief itself shows that you were in possession and confirmation of possession.
Confirmation.
ठीक है, that should be sufficient और क्या है?
Then my humble submission would be, जहाँ तक अभी हम place कर पाए, that if a person is in possession of a property, can he be thrown away without a procedural adoption of procedure under law? Article 300 capital A still exists in the Constitution. Rather, it has been brought by amendment. There are few more judgments, my lord, if I am permitted to place. If it could be kept as parted, my lord,
नहीं
then
सर, नहीं यार, आगे तक
then there is a judgment of a division bench of this honorable court in the case of Ganesh Burman versus State of Jharkhand.
Citation.
No, it's a recent judgment report delivered on 28th of January 2025.
28.
अभी नहीं हाँ 28 जनवरी few weeks before. Copy the- When Jamabandi was created, it must be a Rajati land and must be in possession of the plaintiffs. Then the Jamabandi was created, and mutation upon purchase by these plaintiffs, mutation was done. Everything cannot be said to be illegal and forced.
Which paragraph are you relying? Paragraph 28.
My Lord 28. We fail to understand how the circle officer could determine whether a document is fake or not, as he is not conferred the power of civil court to decide the genuineness of the document or whether it is forgery. Then we learn para 17 to 24 also, the Lordship will learn. Para 17, the Lordship have considered Article 300 capital A of the Constitution of India states that no person shall be deprived of his property save by authority of law. Next, para 18. However, no provision of law is quoted in the order dated 6/8/2020, which empowers the Circle Officer Fatehpur to determine the title to the land in the occupation of appellants or to evict the appellant. The doctrine of separation of power precludes the circle officer, who is a member of the executive branch of the government, from exercising judicial powers. Same principle will apply for deputy commissioner also. Thus, his order is without jurisdiction. My Lord also considers that DC was not having the jurisdiction. The principle is, my Lord, if the order is without jurisdiction, that has to be set aside. We are also of the opinion that the circle officer cannot unilaterally determine the title of the government to the subject land, and only the civil court can do. In Government of Andhra Pradesh versus Thumalla Krishna Rao and others, the Supreme Court has held that if there is a bona fide dispute regarding title of the government to the property, government cannot take a unilateral decision in its own favor that the property belongs to it, and on the basis of such a decision summarily evict someone who is in possession of the property. Here also I was in possession. Now the deputy commissioner cancelled the Jamabandi, took possession and handed over to the BCCL without initiating any land acquisition proceeding even. Then if I am permitted, para 22. This was reiterated in Kaki Horse Rao, Thomas G. from the Workers' Union of India in the following terms. The question involved in Express newspaper's case in relation to remedy of the state person in possession of the land was again considered by a bench consisting of 3 judges in the state of Rajasthan versus Padmavati Devi. In that case also, the question arose as to whether the state government can take recourse to a summary remedy of eviction of a person under the state revenue laws from the land when such person raises a bona fide dispute about his right to remain in occupation over such land. Their lordship held that in such a situation, the summary remedy to evict such person under the Act could not be resorted to.
So the appellate court has held that you have right, title, interest and also possession.
Yes, ma'am.
So you're happy with that? Because they say that you are not in possession. But the appellate court says that you are in possession.
Yes. Possession, my lord, the mutation itself is a proof that
We are not saying, we are just looking at the finding of the appellate.
G.
The finding of the appellate court is that you have right, title, interest and possession.
Possession.
And possession has been declared on the basis of one leader commissioner's report.
No, that is apart from the evidences. my
No,
lord.
that is the main evidence for consideration of possession.
Lord, that is, see, it has been marked for identification as Exhibit X. Exhibit number.
But that
हाँ.
is the document which has been taken care of by the learned
ठीक है.
appellate court
ठीक है.
to
But
say that
apart from that, the mutation itself is a clear proof that I am in possession. अब वो तो Exhibit X है.
आप देखिए ना पैरा नंबर 13 पढ़िए appellate court का.
After going through the above discussions, oral and documentary evidence है उसमें. वो Exhibit X, in my knowledge, my lord, Exhibit X is only marked for identification. अगर वो marked हो जाता है as exhibit such and such, then my lord, I would have heavily relied on that. उसमें सारा कुछ boundaries दिया हुआ है. I find that the defendant respondent have failed to prove that the registered sale deed exhibit 3 and 4 of the plaintiff appellant are bogus and sham documents. They are the finding of a civil court member. They have not brought on record any proceeding of the state government to show that the long-running jamabandi of the plaintiff appellant was cancelled after giving them opportunity after hearing. I further submit that I want to proceed further, that even after hearing, my lord, jamabandi could not be cancelled by administrative side officers. I have already held that long-running jamabandi cannot be cancelled unless there is evidence of fraud and misrepresentation. Who will hold that it was created by committing fraud and misrepresentation? Only a civil court will decide if fraud हुआ था, misrepresentation हुआ था. Executive officer नहीं कर सकते हैं वो चीज. Earlier, the then ASO Sri B.B. Verma, Assistant Settlement Officer, under Section 87 million, there is a provision for correction of Khatiyan million. If I am permitted to read.
सर आप पूरा नहीं पढ़े ना, पहले पैराग्राफ तो पढ़ लीजिए पूरा.
I have already held that long-running jamabandi cannot be cancelled unless there is evidence of fraud and misrepresentation. Earlier, the then ASO Sri B.B. Verma had ordered to publish the record of rights in favor of plaintiff appellant for the suit land against which it appears that the defendant respondents have not filed any appeal or revision. before the competent court. The pleader commissioner report, as discussed above, goes to show that the plaintiff appellant are in possession of the suit land.
ये जो प्लीडर कमिश्नर का रिपोर्ट है ना सर,
जी
ये एग्जिबिट 12 और हुकुमनामा इज एग्जिबिट एक्स फॉर आइडेंटिफिकेशन. आप अपने इंटरनल पेज 6 में देख लीजिए ट्रायल कोर्ट का जजमेंट.
एक मिनट, हुकुमनामा इज मार्क्ड
एग्जिबिट एक्स
आइए.
एंड प्लीडर कमिश्नर रिपोर्ट इज एग्जिबिट 12.
हाँ ठीक है, तब तो ठीक ही किया. प्लीडर कमिश्नर रिपोर्ट विद स्केच.
हुकुमनामा वाज मार्क्ड एग्जिबिट एक्स फॉर आइडेंटिफिकेशन.
वो एक्सेप्ट नहीं किया होगा,
नहीं
विद
किया होगा.
ऑब्जेक्शन किया होगा.
विद ऑब्जेक्शन नहीं, वो प्रूव ही नहीं हुआ ना, क्योंकि हुकुमनामा ऐसे कैसे प्रूव हो.
बट पोजीशन तो है.
प्लीडर कमिश्नर के रिपोर्ट के बेसिस ना आपका
हाँ.
पोजीशन.
Yes, I have not. The pleader commissioner report, as discussed above, goes to show that the plaintiff appellants are in possession of the suit land. So, on the basis of documentary and oral evidence on record, the plaintiff appellants have proved their right title interest in possession over the suit land. The learned lower court has erred in dismissing the title suit 73 of 90. So the judgment dated 17/10/2015 and decree dated 24/11/2015 passed by the then Civil Judge Senior Division 7 Dhanbad in title suit number 73 of 90 are hereby set aside. Both the points for consideration are accordingly decided. It is ordered that the plaintiff appellant have a right title interest in possession over the suit land, and in the result it is ordered that this appeal is annulled.
Pleader commissioner must have been examined as a witness.
My
He was witness number.
एक मिनट में दे देगा.
See, PW2 in para 12 of the cross-examination has stated that BCCL has taken his land.
Later on तो नहीं लिया. But how my position, I was dispossessed, and how the state
That in
government.
the year 84-85,
Huh?
BCCL has taken possession of the land. Pleader commissioner is saying in the year 1992 that you are in possession. So I want to know whether the pleader commissioner has been examined.
One minute.
ठीक है, appellate court का finding है आपके favor में that you are in possession of the property. What about the trial court's finding regarding possession?
Lord, that I will place for my consideration.
Trial court has said that you have failed to prove the title over the property, so far as the trial court is concerned.
In fact, the issues which were framed at page, internal page 4, running page 35, in London trial court, on the basis of pleadings, whereas 6, on the basis of pleadings of the parties, the following issues have been settled. Is the suit frame maintainable? Have the plaintiff got cause of action for the suit and right to sue? Third, is the suit barred by limitation? Fourth, is the suit barred under provisions of Bihar Land Reforms Act, Chotam Act to Tenancy Act, and a specific relief act? Fifth, has the suit been properly valued and is the court fee paid sufficient? Have the plaintiff title and possession over the suit land and the plaintiff entitled to the relief claimed in the suit? To what other or further reliefs the plaintiffs are entitled to? Nowhere the learned court below has framed any issue whether cancellation of Jamabandi was legal and proper.
Appellate court has framed the issue.
G.
So,
The learned lower appellate court has considered everything of the trial court and then came to conclusion that these are the only 2 points to be decided to determine the issue. And one of the issue was whether the cancellation of Jamabandi was according to law.
was there any mutation in your favor?
Yes.
What is that? Where is that order of mutation? That is exhibit number?
1 minute time. each जगह पर if I am permitted to interfere, exhibit 7 is the original हुकुमनामा. वहाँ जो exhibit वो mark as exhibit X कर दिए हैं. Lower appellate court का page 6 में देखिएगा, exhibit 7 is the original हुकुमनामा.
Exhibit 7.
जी. So that was a matter of consideration. It was alive throughout the cases. It is still alive. My lord, exhibit 10 is the certified copy of order sheet. Exhibit 10 of the certified copy of the order sheet of mutation case number 91 into bracket Roman 10/8283. It is in my favor.
So 8283. आप देखिए वहाँ पे है डॉक्यूमेंट फ्लैग किए हैं.
This is the one case we not where it deprived this honorable court. Obliged, deeply obliged that my lords have given us a million. अंचल अधिकारी, आई एम रीडिंग पेज 71. उसके पहले भी एक और डॉक्यूमेंट हम पढ़ना चाहते हैं. I had seen it on the other day when my lord permitted me to look into it. The exhibit 9. This is continuous Khatiyan. थाना तो चाची, परगना नवागढ़, मौजा नंबर सो एंड सो, गैर आबाद मालिक 125, 280, 248, 197, etc. there is a recording correction of notification so and so. Then I turn to the page of the details, name of village, Bhim Kanali, name of the parties, मनीलाल सिंह चौधरी. ये कैसे हो जाएगा कि ये सरकारी जमीन? मनीलाल सिंह चौधरी was ancestor of my vendor. मनीलाल सिंह चौधरी, पिता आशीष सिंह चौधरी, जाति सज्जन सो अंश 8 आना. एंड दूसरा है महावीर सिंह चौधरी, पिता आशीष लाल सिंह चौधरी, सेम फादर, जाति सो अंश 8 आना. 50-50% is the right title and interest of the parties. Name of party under whom holding. उपस्थित मालिक so and so Babu Nilkant Narayan Singh. He was the superior landlord. I know it. किसी महर मोकररी, that is a permanent settlement था उसको. हक रेंट सालाना, सेस हाल सेस, $75. Then amount of rent is 75 पैसा 6 आना, 75 रुपया 6 आना, और सेस भी वही है. बाबत पट्टा मुकर्ररी सहरी तारीख 14/8/1897. आता बनवारी लाल सिंह, आशीष लाल सिंह चौधरी, my father's. This is my lord exhibit 8 and 9. And 10 I may be permitted to read. This is dated 25th of March 83. May I read my?
पढ़ लिए तभी आपको बताएंगे.
जी.
हम पढ़ लेंगे.
अच्छा.
आप पढ़िए.
अंचल अधिकारी कार्यालय बाघमारा दाखिल खारिज मुकदमा संख्या 91 Roman 10 82-83 श्री शिव कुमार राय साकिन भीम कनाली. अभिलेख उपस्थित किया गया. आम इश्तेहार का तामीला प्राप्त अभिलेख के साथ संलग्न है. किसी ने किसी प्रकार का कोई आपत्ति नहीं किया. ये सीओ ही बोल रहे थे, वही तो स्टेट के रिप्रेजेंटेटिव. आवेदक उपस्थित है. कर्मचारी का जांच प्रतिवेदन प्राप्त हुआ. इसे देखा. कर्मचारी ने अपने जांच प्रतिवेदन में उल्लेख किया है कि आवेदक प्रश्नगत भूमि को केवल दलील संख्या 12735 28/11/82 से खरीद कर साल पर दखलकार है. जमीन रैयती खाते की है. तो रैयती खाते की जमीन है. प्रश्नगत जमीन की लगान श्रीमती देवरानी देवी, पिता पति श्री भुवनेश्वर सिंह. He is the husband. He was the one of the जमींदार और family, one of the member of the जमींदार family. साकिन भीम कनाली नाम से जमाबंदी नंबर 979 वसूल हो रहा है. दाखिल खारिज करने से कोई आपत्ति नहीं है। कर्मचारी ने आवेदक के नाम से दाखिल खारिज करने की अनुशंसा किया है, अतः कर्मचारी के अनुशंसा के आधार पर आवेदक श्री शिव कुमार राय, पिता श्री राधाकांत राय,
देखिए सर, ठीक है, there is a mutation in your name. What do you have to say, appellant?
Besides what I have already submitted,
Yes.
first, Your Lordship, it is the suit brought by the plaintiff, that is the respondent, for declaration of right, title and interest. In this suit, the onus is on the plaintiff to prove, Your Lordship, his right, title and interest. Lordship, you kindly permit me to place only two paragraphs from this judgment. First, paragraph 15. I am not reading the entire details and reference to other previous judgments. Paragraph 15, it is a right of law. In a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendants would not be a ground to grant any relief to the plaintiff. After this, I am submitting contest of paragraph 9 of the appellate court judgment, where they said that defendants failed to prove. Lordship, thereafter, Lordship, kindly come to Lordship, paragraph 19. Same thing has been reiterated. The legal position, therefore, is clear that the plaintiff in a suit for declaration of title and possession would succeed only on the strength of its own title, and that could not be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question whether defendants has proved their case or not. We are of the view that even if the title set up by the defendant is found against in absence of establishment of plaintiff's own title, plaintiff must be non-suited. My Lordship, may kindly see para 13 of the trial court judgment, appellate court judgment, Your Lordship. The court says, Your Lordship, that after going through the above discussed oral and documentary evidence, on record, I find that defendant respondents have failed to prove the registered salary discharge. The onus was not upon me. It was upon the plaintiff to prove it beyond all reasonable doubt. Now, Your Lordship, my learned friend has argued much upon the Your Lordship's Kumnama, Your Lordship, on the basis of which they are claiming a mutation. Lordship, the issue has also been considered by this honorable court.
Yes.
In the case, I am just giving the judgment. Lordship, permit me to place para 9 here, Lordship. I have considered the submission of the parties and gone through the relevant materials on record. The facts of the case narrated above shows that it throws few questions which must be dwelled upon hereinafter. Settlement, Lordship, here it is very important. Settlement of land by ex-landlord in favor of the petitioner for claiming right, title and ownership over the property and possession thereof would depend also upon compliance of the provisions of Bihar Land Reform Act 1950, which contemplates furnishing of return by the ex-landlord containing the names of the persons, description of the area and the plots of which settlement has been made by the ex-landlord, and that too before the cut-off date, that is 1/1/1946. Nothing has been brought on record, Your Lordships. It is clear case that the respondents that zamindari returns furnished by the erstwhile landlord in terms of returns furnished by the ex-landlord, petitioner's name does not figure showing any valid settlement made by it in terms of Bihar Land Reforms Act 1950. It further appears that except for one rent receipt issued in the year 1971, here also rent receipts of the year 1971 and 1983, bearing number such and such dated 31/3/71 in respect of area of 219.98 acres of land of Khata number 1 and 383, there is no rent receipt issued thereafter in favor of the petitioner. Surprisingly, petitioner never made any effort for issuance of rent receipts before approaching the court in the year 2015 by a present and thereafter the matter. The issue is, Lordship, Bihar Land Reform Act says that prior to land reform, if there is a settlement, Lordship, that must be reflected in the zamindari return. Actually, it is not their case that zamindari return was filed wherein their name was reflected. Secondly, Lordship, from the date of settlement till vesting of zamindari, not a single rent receipt has been produced. Lordship, thirdly, Lordship, on the issue of Lordship, the whether Sada Hukumnama can confer title or not, this issue has been considered by this Honorable Court in a first appeal, Your Lordships. Para 21 is relevant, may I read out? Para 22 issues were framed. Whether Hukumnama is a valid title document and the learned court will order in not considering the same whether to declare title.
You have LPA order.
I beg.
सर वापस
Para 22.
Para 21 here.
20.
So far as the point for determination regarding Hukumnama concerned, it is pertinent to mention here that it is settled principle of law that Hukumnama wherein the settlement of a Rayati interest with any person has been reduced into writing requires registration, and if it is not registered, it is inadmissible and no evidence could be given as to its terms and contents, as has been held by the Honorable Supreme Court of India in the case of S. Sita Maharani and others versus Chedi Mato and others reported in AIR 1955 Supreme Court 328. It is needless to mention that by the Hukumnama filed in this case, the settlement of the Rayat interest with the plaintiff and their predecessors in interest has been reduced to writing. Hence the same requires registration, but the same has not been registered and it is not inadmissible. No evidence could have been given as to the terms and contents. Hence, the same is of no help to the plaintiff. Hence, the learned trial court was not in error in not considering it.
That's all.
Yes, sir. And we have, Your Lordship, since the trial court's judgment, Lordship may kindly come to internal page 9 of the trial court judgment. It is running page 39. Lordship, for the first sub-para, from the perusal of Exhibit A, it appears that Exhibit A is a general notice issued by the Circle Officer Bagmara Office, for which notices have been given to each public that the land, including the suit land, is of a government land and is going to be settled in favor of defendant number 4 and 5. If the person has made objection, may file their objection up to such and such day. Since the general notice was issued by the Circle Authority Bagmara, now from Exhibit B it appears that disputed land was transferred to by the authority of the government to defendant 4 and 5, and also given position of them. Since defendant of 1 to 3 have not led any evidence, but they have stated that in their pleading WS was that opening of Jamabandi and grant of rent receipt does not create title. It is a subtle principle of law. It does not create any title. And Jamabandi has been opened in connivance with the staff of Panchal, which is illegal. So the order of cancellation of Jamabandi is not illegal in the eyes of law. It has been further pleaded in the written statement that any transfer of the government land by the Devrani Devi to plaintiff is illegal and has got no value in the eyes of law, and the claim of the plaintiff is denied. Now, as from the perusal of Exhibit A and B, it appears that although these documents have been brought by the defendant of 4 and 5, but these documents relates to defendant number 1 to 3, who are the government authority, and after taking the pleading of the defendant 1 to 3 with Exhibit A and B, it appears that the disputed land was government land and the government of Bihar has title and possession over the land, and the government was, after inviting objection from the general public, transferred the same to the defendant number 4 and 5. It is admitted position that both the parties that the disputed land was Gyanabad Malik land. It further appears that the disputed land has been transferred to Devrani Devi through a Hukumnama. From perusal of Exhibit 7, it appears that it is a Sada Hukumnama and it is not registered, and defendant plaintiff number 2 has been examined
That's right, we have heard it. That should be sufficient.
This.
The argument of the learned counsel for the appellant was recorded in the order dated 6th of February 2025. Today, the learned counsel for the respondents has advanced his argument. The learned counsel has submitted that the learned appellate court has taken note of various judgments while recording that running Jamabandi cannot be cancelled and that the defendants had not produced any document to show that the plaintiffs were given notice prior to cancellation of their running Jamabandi. He has also submitted that the creation of Jamabandi gives a valuable right to the rayans. The learned counsel has further submitted that the possession of the plaintiffs has been also considered by the learned appellate court by referring to various oral and documentary evidences. And the learned appellate court found that the plaintiffs have right, title, interest and possession. He has also submitted that Jamabandi was also created in favor of the plaintiff after their purchase of property in the year 1982, while mutation case number 91/10 of 82-83, which is exhibit 10 of the present case. He has submitted that the plaintiffs had purchased the property which was initially settled in the name of Devrani Devi by way of Sada Hukumnama by the ex-landlord way back in the year 1942, and there is enough material to show that the Sada Hukumnama was followed by possession and numerous rent receipts were produced by the plaintiffs before the learned court for consideration. He has relied upon the judgment passed by Honorable Patna High Court, reported in AIR 1968 Patna 302 FB, Mosamat Ugni and another versus Chaua Mehto, paragraph 16 and 17. He has also relied upon the judgment passed in LPA number 413 of 2024, decided on 28/1/2025, paragraph 23, 24 and 28. The learned counsel submits that both the substantial questions of law are fit to be answered in favor of the respondents and against the appellant, and the appeal is fit to be dismissed. That's all. कुछ छोड़े आपका? आपके सारे पाठ लिखा दिए? कुछ छूटा है तो बताइए.
नहीं, my friend has challenged this registered sale deed.
Sir,
Then onus is on him to prove that how it was not genuine, because
they have not challenged the sale deed. Have you challenged the sale deed?
No, they have filed a suit for declaration of their title.
yes,
They have to
on the
show
basis
that-
of a registered
नहीं
sale.
ठीक है, अभी फर्दर आर्गुमेंट की बात नहीं
जी
कर रहे हैं.
हाँ.
आपका सारा आर्गुमेंट रिकॉर्ड कर लिए
जी
ना?
हाँ.
The learned counsel for the appellant in response has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2014 bracket close to SCC 269 paragraph 15 and 19 to submit that the onus is always upon the plaintiff to prove his case. Any lacuna in the case of the defendant's case will not give any advantage to the plaintiff. The learned counsel has submitted that it was for the plaintiff to prove that the vendor of the plaintiff had title to transfer the property in the name of the plaintiff. The learned counsel has further submitted that has also relied upon the judgment passed by the Honorable Supreme or this court reported in 2016 SCC online JHAR 1003 paragraph number 9 to submit that the requirement of claiming property through Sada Hukumnama and the provisions of Bihar Land Reforms Act has been duly considered. Filing of return is one of the essential steps in the matter of claiming settlement and continuation of settlement under the Bihar Land Reforms Act. He submits that not even a single rent receipt has been produced by the plaintiffs which were relating to the period prior to vesting, and even after vesting the oldest rent receipt is sometimes of the year 1972. He has submitted that the rent receipts which has been produced by the plaintiffs are of no consequence. The learned counsel has also relied upon the judgment passed by this court in First Appeal number 29 of 2009, paragraph 21 to submit that mere hukumnama is of no consequence. The learned counsel has thereafter referred to the judgment passed by the learned trial court to submit that the learned trial court, after considering the materials on record, has given a finding that the disputed land was government land and the government of Bihar had title and possession over the said land, and government, after inviting objection from the general public, transferred the same to the defendant number 4 and 5. He asserted that defendant number 4 and 5 are in possession of the property. Say, by virtue of transfer made by the
State government.
the then government of Bihar. Could you conclude it?
There is no answer to the order of the settlement officer under section 87 of the CNT Act, where correction was made in the Khatian. A wrong recording made in the Khatian was the state of Bihar, that has been corrected, and name of Shiv Kumar Rai has been ordered to be inserted in place of the state of Bihar. That shows that the land didn't belong to the state, and that has been done in pursuance of a provision in the Act, CNT Act.
That is exhibit number?
Exhibit number, madam. One. Exhibit number 11 small a. 11 by small a. Certified copy of order dated 29/1/2009 passed in case number so and so under section 87 CNT Act. My lord, will find at page 6
इन्हीं
of
के submission में लिखे हैं. The learned counsel for the respondents has also referred to exhibit 11 by A, which is a certified copy of the order dated 29/1/2009 passed in case number 5125 of 2005 under section 87 of Totonac Tenancy Act to submit that the record of right was corrected by virtue of this order,
My lord.
and the wrongful entry of the record of right was in favor of the plaintiffs.
Yes.
Also, this has been replied as a proposal. He did not argue that right there. एक ही चीज है बता देना. Also, this was done during the pendency of the suit, and it was beyond pleading, which the learned trial court has said. You also in internal page to that.
That
In
is an exhibit.
response में लिखिएगा.
Government
The
record
learned counsel has
In
submitted
due
that
discharge of the official
the
duty.
said order was passed during
Yes.
the pendency of the trial.
Yes, 2009. Suit is of the year 1990.
during the pendency of the trial, and the suit is of the year 1990, and accordingly the exhibit 11 by A has no relevance, and it was passed, and there is no corresponding pleading to
Pleadings
that.
to that.
My lord will kindly consider.
अब हो गया, अब सब
They have
consider
not challenged it. Absolutely no appeal, no revision, nothing. Appeal was before the district judge. They could have come.
करें। तो orders करना इसको। पहले judgment सब करते हैं। हाँ जी।
From the list for judgment item 1 second appeal 196 of 2020.
The substantial question of law has been answered in favor of the respondent and against the appellant. This second appeal is hereby dismissed.
From notified list item 1 WPL 1530 of 2024.
The impugned award does not call for any interference except to the extent it relates to direction regarding consideration of the case of the concerned workman for regularization.
Item 2 WPL 1544 of 2024.
Disposed of in aforesaid terms है ना? ये वाला भी ये 1/301 disposed of in aforesaid terms. हाँ, disposed of in aforesaid terms. क्योंकि partly इसमें हम लोग relief दिए हैं. As a cumulative effect of the aforesaid findings, the impugned award does not call for any interference except to the extent relating to the direction regarding consideration of the case of the concerned workman for regularization, which has been set aside in paragraph 16.
1530 and 1544
Disposed of in aforesaid terms.
Item 3 WPL 3826 of 2024.
इसका भी same. Disposed of in aforesaid terms. One 96 dismissed. Second appeal is dismissed. Orders करना है. Orders हो. Fix आप कौन सा fixed है? आप लोग का तो केस नहीं हुआ. आज तो बहुत सारा केस फिक्स था लेकिन टाइम नहीं. अब क्या करना है बताइए.
Will your lordship take it up on then Monday then? Whatever is convenient.
देखिए एक दिन में इतना केस नहीं हो पाता.
नहीं
ऑर्डर से तो चला जाता
I
है.
will not say anything.
और ऐसे किसी भी केस को रश करके दूसरा केस नहीं कर सकते.
Absolutely, according to your lordship's convenience, whatever is.
जब तक आपको समझ में नहीं आता हम फाइल बंद नहीं करते.
नहीं,
बस
पूरा
सीधा सा बात है. वो कितना ही
कोई-
टाइम क्यों ना लग जाए
नहीं
इसमें.
कोई जल्दबाजी नहीं. whatever is convenient.
कोई कोई एक एक केस में ना डेट थोड़ा सा देंगे, है ना? अगला हफ्ता में स्प्रेड करके देंगे, अगला हफ्ता का डेट दिखाइए ना, पता नहीं चलता कितना कौन सा केस।
But my only prayer would be
Sabah.
second half.
सात तारीख को एक केस मिक्स्ड है।
Serial number 3 going after Holi.
आपका पाठक है कि नहीं है, सुने हैं कि नहीं सुने?
पाठक हिस्ट्री
फिक्स किया है सर। उसको फिर जिसको हम नहीं सुने हैं ना, उसको हम आफ्टर होली कर देंगे, और जिसको हम सुन लिए हैं उसको होली के पहले ही रखेंगे।
ठीक है।
लाइए एक एक बार एक एक करके फाइल लीजिए, जो भी पांचों केस जरा कॉल करेंगे। आपका फर्स्ट अपील तो सुना हुआ है। आई जस्ट गिव इट जस्ट
Item 2 from supplementary list.
ये पाठक है। हाँ, कब करें इसको बताइए।
Whatever is convenient.
कल 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 का क्या पोजीशन है?
Tomorrow.
अच्छा कल
Then,
रेफरेंस है,
they have
कल
difficult.
तो रेफरेंस है। मंडे
Wednesday or Tuesday.
28 के बाद 3 तारीख को खुल रहा है, 3rd को रखते हैं, 3 तारीख को, ठीक है, 2:15 बजे,
ठीक है.
ठीक है। FA number 3 of 2023, as the court time is over, the case could not be taken up for further hearing. Post this case on 3rd of March 25 at 2:15 as first case.
Yes.
ठीक है, पार्टनर है तो हम लोग वही करेंगे। और आगे बताइए और कौन सा है? आप लोग थोड़ा नोट बना लेंगे ना प्लीज। अब तो देखिए कंटूर्स तो पता ही है,
Yes, yes, sir.
कंटूर्स आपको पता ही है, आपने बनाया है तो दे दीजिए, आप भी बना
छोटा सा
लीजिए।
है, मतलब,
हाँ,
but
नहीं।
according to my
नहीं, ठीक
convenience,
है।
I have prepared.
नहीं तो आप एक बना देंगे ना,
अच्छा,
तो हमको
ठीक।
इजी होगा,
ठीक,
आप ही
ठीक है।
बना दीजिए।
ठीक.
You know we have heard it, we know the contours of the arguments, right? थोड़ा सा बनाइए, अगर मान लीजिए आर्गुमेंट के बाद आपको लगे कि रिवाइज नोट देने की जरूरत है, that can also be allowed, ऐसा कोई बात नहीं है।
And your lordship, in this, because this first appeal points for determination.
Yes, you just indicate that also.
Yes.
Point for determination भी आप लोग, वो तो आप लोग jointly फाइल कर सकते
हाँ
हैं।
हाँ ठीक है, हम डिस्कस.
ये बताइए ये कौन सा है?
Item 2 from daily list. Second appeal 380 of 2017.
और उस पे खाली 10 मिनट के लिए हुआ था, स्टेट अपीयर नहीं किए थे।
अच्छा, तो इसको छुट्टी के बाद रख दें, ठीक है? आफ्टर वेकेशन। आप तो टाइम ही आप लोग को चाहिए।
नहीं, हम तो चाह रहे हैं
हम ऐसा
हो
नहीं
जाए।
चाहते, हमको अलॉट ही हुआ है परसों।
अच्छा, बड़ी अच्छी बात। लिखिए। Second appeal number 380 of 27. Counsel for the parties are present. The learned counsel for the respondent state has submitted that he has been allocated the file only day before yesterday
21
on
21
on 21 to 2025 and he needs some time to prepare it. बताइए, सुनने लग जाएंगे फिर आपको टाइम नहीं देंगे।
24 टू कर दिया, 21 टू हमने कर दिया यहाँ से।
अच्छा 24, ठीक है, कब रख दें बताइए?
आज your ladyship will say.
Post on 18th March. नेक्स्ट बताइए।
Time है.
नहीं टाइम मत दीजिए, क्योंकि पता नहीं 18 मार्च को कौन सा बेंच है।
Important case fix.
18 का?
आ गया तो fix notice नहीं.
अच्छा 18 को 19।
Item 3. WPC 4007 of 2020.
इसमें दे दीजिए 2nd अप्रैल। 2nd अप्रैल।
Second appeal.
बस हो गया।
Item 21 from daily list WPS 479 of 2015.
ये क्या है?
Sir, removal matter.
सॉरी,
It's a removal matter.
ये
It's an assigned matter.
असाइन केस। तो अभी क्यों कॉल कर रहे हैं? ऑर्डर्स में क्यों आए हैं?
नहीं ऑर्डर्स में नहीं है, टाइम फिक्स है। Admission okay.
Admission.
Okay, 2.6.
इसमें कोई सुप्रीम कोर्ट का ऑर्डर वगैरह तो कुछ नहीं है ना, ऐसे सिर्फ असाइंड है मैम. Post on 2nd April.
Fees.
ऑर्डर्स करेंगे आप लोग हैं तो कर लेते हैं, हमको कोई दिक्कत नहीं. जो लोग एपियर हो जाते हैं उनका कर लेते हैं, जो लोग नहीं एपियर होंगे उनका छोड़. ठीक है, चलिए कॉल करिए.
From supplementary list for orders item 6, 2nd April 101 of 2021.
अब बताइए ये ऑर्डर्स में किस लिए है? सोल रेस्पोंडेंट वकालतनामा फाइल किए हैं. When did he die?
It has came in the service report.
Sorry?
Service report में आया है.
सर्विस सोल रेस्पोंडेंट. अच्छा, आइए कौन सा आइए नंबर बताएंगे.
आइए फाइल
1672.
1672. लीगल ईयर्स कौन है?
If I
हाँ, लीगल ईयर्स कौन है?
litigation, we haven't filed the IA for substitution at the end.
We have not yet filed it.
No.
Sole respondent has expired. लिखिए. Essay number 101 of 2021. Counsel for the appellant submits that the sole respondent has expired and he seeks adjournment. Post on 2nd of. Next.
Item 7, first appeal 132 of 2024.
हाँ बताइए ये किस लिए?
आइए पर लिमिटेशन में.
Sorry?
1312 of 6/2024 में 36 days.
I can't get you.
Take आइए limitation.
36 days delay. Limitation.
Limitation. बताइए आपको क्या बोलना है limitation?
No plausible reason has been explained. Just see we went to the lawyer.
First appeal है ना?
अब हम क्या, मेरा कहने का मतलब क्या है? It is a statutory appeal, it has to be है. पहले तो ये एडमिट होता था, आपकी एडमिशन में आएगा, उसके बाद एडमिट होगा. पहले तो जब था तो रजिस्ट्रार के यहाँ से एडमिट होता था, फिर उसका एडमिशन में होता था. तो
आप सोल रेस्पोंडेंट हैं?
नहीं, डेप्यूटी कमिश्नर इज आल्सो देयर.
स्टेट का कोई है? लिखिए सर. IA number 13126 of 2024 in FA number 132 of 2024. A petition has been filed seeking condonation of delay of 36 days. Post this case on 2nd of April. In the meantime, if so advised, the respondents may file a reply to the petition for condonation. आपको अपोज करना है तो एफिडेविट कर देंगे. कंडोन कम कर ही देंगे मेरे पास. नहीं, आप अपोज करेंगे, स्टेट है नहीं. देखिए 4:45 हो रहा है, उनका किसी का एब्सेंस रिकॉर्ड करके हम कोई ऑर्डर नहीं कर सकते.
By formal objection may be noted down in the order making.
From daily list for orders item 14, second appeal.
State is a formal party.
State is the formal party. I am the main.
अच्छा चलिए लाइए इनका डिले कंडोन कर देते हैं.
I am the main contestant.
Listen, IA has been filed for condonation of delay of 36 days. The learned counsel for the respondent number 1 to 3 has submitted that they are the contesting respondent and the deputy commissioner respondent number 4 is just a formal.
I don't know what claims they have against the deputy commissioner. That I don't know.
He has opposed the prayer for condonation of delay by submitting that proper explanation has not been given. However, no counter affidavit as such has been filed to the interlocutory application. After hearing the counsel for the parties and considering the amendments made in the petition for condonation of delay, paragraph 7 to
4 to 7.
para 4 to 7, and being satisfied, the petition for the delay in filing the first appeal is condoned. IA number such and such is allowed. There is no further defects. Admit, call for LCR. Since respondents are already appearing, no notice need be issued. State को सर्व कर दिया? हाँ?
नाम क्लियर कर रहा है
स्टेट का कर रहा है ना? डेट दे दीजिए इसमें 8 अप्रैल। हो गया ऑर्डर्स खत्म? और देखिए कौन सा ऑर्डर्स है?
From rail list orders item 14, second appeal 315 of 2016.
Yes. Petitioner absent है ना? आप हैं? हाँ बताइए।
इसमें बनेगा आइए 15217 का जवाब है।
देना है?
जी हाँ, फाइल करना।
देखिए, ऐसे नंबर 315 of 2016. Learned counsel for the parties are present. Counsel for the appellant prays for time to respond to IA number 13217 of 2024. Correct? You know, आपने फाइल किया है.
Yes, Lordship.
Close this case on 8th of April. The reply should be filed by 3rd of April.
Appearance date. Item 15, second appeal 74 of 2017.
You have filed for
substituting the service of notice.
for substituted service of notice. किसको सर्व नहीं कर पा रहे? किसको सर्व नहीं कर पा रहे?
Respondent number 2.
Respondent number 2. देखिए, आइए नंबर 10120 or 41 of 2024 in essay number 74 of 2017, the learned counsel for the appellant has submitted that his petition has been filed for substituted service of notice through newspaper upon respondent number 2. He has submitted that in spite of best of efforts, the respondent number 2 could not be served and was not available on the given address. Considering the aforesaid petition, considering the averments made in the aforesaid petition, IA number 12041 of 2024 is hereby allowed. The counsel for the appellant is directed to the substituted service of notice through newspaper. कौन सा होगा?
लोकल न्यूज़पेपर
कहाँ का है?
गुमला
थ्रू न्यूज़पेपर प्रभात खबर, एक ही न्यूज़पेपर चलेगा. थ्रू न्यूज़पेपर प्रभात खबर having circulation in Gumla be published. The format of notice be furnished by the petitioner to the office within a period of 10 days from today. The office shall do the needful and verify the format so furnished by the appellant and hand it over to the counsel for the appellant for publication. The affidavit enclosing the newspaper in original be filed by the appellant by 2nd of May. Post on 6th of May.
Item 16, second appeal 125 of 2017.
16.
Item 16.
Yes. Substitution petition lordship. And respondent number 1 Tej Naran Rai who died 28/9/24. इसका legal years lordship I am stated in para 5. One wife and 2 sons and 5 daughters.
आई नंबर 12 क्या ये देखिए कैसे लिखते पता ही चलता है. नंबर आई नंबर लिस्ट से देखिए 1224 आइए नंबर
Item 16, 1224 of 2020.
आइए नंबर 1224 of 2025 in essay number 125 of 2017. The learned counsel for the appellant has submitted that the respondent number 1 has expired on 28/9/2024 leaving behind the legal heirs and successors as mentioned in paragraph 5 of the interlocutory application. आप लेंगे क्या नोटिस जाएगा? Let notice be issued to the proposed legal heirs and successors of respondent number 1 for which requisite under ordinary process be filed within a period of 10 days from today.
3 weeks का समय दीजिए।
नोटिस फाइल करने में ऑर्डिनरी प्रोसेस में इन द इंटेलेक्चुअल एप्लीकेशन सिर्फ आईए का नोटिस फाइल करना
आइए
सिर्फ आईए का
10 days or so.
हाँ 10 days post this case on 15th of April 15th April
15th
awaiting
April.
service report.
Yes.
Appearance will be. Item 17, second appeal 248 of 2018.
So appellant died in 2018. I filed the IA 311 of 2007 and 3117 of 2022. That is the substitution petition. Sole appellant died of 13.
When did he die? When did the sole appellant die? When did he die?
13/11/2018. I filed the petition late, therefore I filed this limitation petition also.
Where is the limitation?
And setting aside abatement petition.
Just a minute. 3119 of 22, then limitation petition कौन सा है? 3118 of 22 and
3122.
3117, 3122, 3123 and
3117 of 2022. The 117 the substitution. आप क्या क्या फाइल किए हैं भाई? रेस्पोंडेंट नंबर 1 का क्या क्या फाइल किए हैं?
4 petition filed. One is substitution petition, one is delay in filing the substitution petition,
हाँ,
one
ठीक
is setting aside abatement petition,
और चौथा?
and one is limitation petition for filing setting aside petition late.
Sorry?
Actually 18 में बन गए थे ना,
हाँ.
तो हम 22 में फाइल किए हैं तो
वो तो लिमिटेशन में आ गया होगा आपका.
लिमिटेशन में
सेटिंग असाइड अबेटमेंट फाइल किए
जी
और सब्स्टिट्यूशन फाइल किए.
जी.
चौथा पिटीशन क्या फाइल किए?
चौथा petition setting aside abatement तो 6 महीने में हो जाता है as per the act.
हाँ.
तो उसको सेटिंग असाइड हुआ नहीं है, लेकिन बाय जुडिशियल ऑर्डर नहीं हुआ है, लेकिन वो तो प्रिकॉशन है भाई.
कहाँ है रेस्पोंडेंट?
That is 3119.
Respondent essay number 248 of 2018. The learned counsel for the appellant submits that 4 interlocutory application has been filed in connection with substitution of deceased appellant number 1 who died on 13/11/2018.
Legal heirs are 12.
Just a moment. The name of legal heirs and successors have been mentioned in paragraph 4 of the interlocutory application, and their wakalatnama has also been filed.
Yes.
And their wakalatnama has also been filed. Propose this case on 11th of March 2025 in the supplementary cause list. In the meantime, it will be open to the respondents to file their. ये तो admitted होगा ना? सब लोग appear कर रहे हैं?
Appeal has not been admitted. There is delay in filing the.
Appeal has not been admitted.
No, madam. There is delay in filing, 16 days delay in filing the appeal also. For
Just
that,
a minute.
IA number
इसका ऐसे मत करिए. Let notice be issued to the proposed legal heirs and successors अच्छा अपीलांट का है ये, नोटिस करके ही ना आपका कंट्रोल करेंगे, क्या करेंगे आपका
अपील
सब्स्टिट्यूशन?
ही एडमिट नहीं हुआ है, इसलिए नोटिस करने की जरूरत नहीं
भाई आपका अबेट कर गया, सब कुछ हो गया, तो
अबेट
बिना
नहीं हुआ ना, जुडिशियल ऑर्डर तो पास हुआ नहीं।
नहीं ऐसे भी तो अबेट कर गया, इतना 2018 का डेटा फाइल किए 2022 में, तो अगर आप खबर नहीं करेंगे तो अबेट तो हो ही जाएगा ना। आप जब फाइल करेंगे तब अबेट होगा ऐसा नहीं है ना।
But since there is no judicial order, therefore I am
नहीं ये सारे एप्लीकेशंस पर हम लोग नोटिस करेंगे, बिना नोटिस किए इस एप्लीकेशंस को हम अलाउ नहीं कर सकते। कितने रिस्पोंडेंट्स हैं आपके केस में?
there are 30 respondents.
नोटिस तो
More than that.
Let notice be issued to the respondents on all the aforesaid applications, interlocutory applications, for which requisites be filed within a period of 1 month from today. चारों में आप नोटिस कर दीजिए, ठीक है?
और अपील पिटीशन,
अपील में तो अभी जब तक एडमिट नहीं होगा तब तक क्या ही होगा, वो आएंगे तब देखेंगे। Post this case on 22nd April, 1st of May, awaiting service.
registered ordinary both.
Ordinary post, local है ना?
No, it is Dalton.
मतलब लोकल यानी कि झारखंड का है ना, झारखंड के बाहर ऑर्डिनरी प्रोसेस सर्व करना बहुत मुश्किल है।
Thank you.
Item 18, second appeal 148 of 2019.
This is your case. बताइए।
File for substitution respondent 1.
You are filed?
Yes.
IA number?
457.
When did you file? IA इसमें नहीं है? IA?
457. Actually, recently filed. Kal ye first.
अच्छा बताइए ना, किसमें उसमें IA नंबर?
457. 25.
2457 of
25.
20. लीगल ईयर्स का कहाँ है?
Para 3.
Para 3. Who has expired?
Respond number 1.
Respondent.
The date of his death is not within our knowledge. That we have specifically stated.
That's right. लिखिए, इसको मंगा लेंगे, ठीक है? IA number 2475 of 2025 in SA number 148 of 2019. 2457. It is an admitted second appeal.
No. Pending.
Counsel for the appellant has submitted that the respondent number 1 has expired, but the date of death of respondent number 1 is not within the knowledge of the appellant. The details of legal hears and successors has been mentioned in paragraph 3 of the interlocutory application. Let notice be issued to the proposed legal hears and successors of respondent number 1 in the interlocutory application and also to the other respondents in the second appeal, for which requisites be filed within a period of 1 month.
2 weeks. I have to take steps for notice in this IM.
IM.
Okay.
Within a period of 2 weeks
Yes.
in the interlocutory application. A post on 30th April awaiting service.
Item 19, first appeal 99 of 2024.
Note से IA number 10977 of 2024.
क्या है ये?
There is a delay of 688 days also in filing the appeal. And wrong size we mentioned draft number. Due to inadvertence in bona fide mistake, Lordship, the first appeal was filed before the learned district judge.
Do you have any objection? FA number 99 of 2024. Counsel for the parties at present. आपको नोटिस हुआ था क्या इसमें? IA में?
A notice is given.
You are the sole defendant. Sorry?
There are two respondents.
You are appearing for both of them? Counsel for the
I think that he is
respondents.
appearing only respondent number 2. According to office notes also.
Wakalatnama of respondent number 1. LCR and Wakalatnama of respondent number 1 is there. What about respondent number 2? Respondent number 2. Respondent number 2 का भी वकालतनामा आ गया है, शीला देवी.
2 की तरफ से दिया था.
शीला देवी का भी है. दीपक ये यहाँ पे लगता है कुछ एरर है लिखिए. FA number 99 of 2024. The counsel for the parties are present. Counsel for the respondent number 2, Mr. Mahesh Tiwari के साथ में. Mr. Respondent appellant and respondent number 2 are present. Counsel for the respondent prays for some time to respond to the interrogatory application seeking condonation of delay. How much time?
4 weeks.
Posed this case on 27th of March 2025. The counter affidavit to the interlocutory application, if any, be filed by 25th of March.
Article 20, first of the 6 of 2020.
By order dated March 16 January 2025, the appeal was admitted. Also directed us to deposit special messenger cost. We have already deposited. Now the LCR have been received.
So why
as
is
per
it?
the office law. Not because it was fixed for awaiting LCR order.
Okay, LCR has come.
That is the office law.
आ गया.
So any date may be fixed.
Appeal admitted on. Respondent appeared है.
State response.
State respondent. Okay. FA number 6 of 2025. It is reported that the records from the concerned court has already been received. Office is directed to place this case under the heading for hearing on सिक्स्थ ऑफ मार्च. डिस्पोजल में नहीं डाल रहे हैं, वो हियरिंग में आएगा सर. ठीक है, तो रेगुलर लिस्ट में आएगा.
जी. On that day itself, your lordship pointed out that is very simple point which requires to be remanded.
तो सिक्स्थ को हम लोग सप्लीमेंट्री कॉस्ट लिस्ट में डाल दें.
कहीं भी.
ठीक है, ठीक है, सप्लीमेंट्री